Welcome to Q&A, Social Security Disability Today. This program is brought to you by the Reeves Law Firm, representing you and your Social Security and disability needs. If you have a problem or questions regarding Social Security and disability, call attorney Anthony Reeves. Is your host, attorney Anthony Reeves.
I know I talked about this in another video where I said, what should I do after the Social Security hearing? But let me tell you again, because I want to make sure I hit this appropriately. What happens to the case itself? And I know I talked about this earlier, but let me reiterate this again. First thing, the case goes to when the judge, after the hearing, when the judge has determined that they're going to make a written decision, which is usually what happens, it goes into one or two piles: post-hearing development, post-hearing review. Post-hearing development typically means the court needs to develop the case further, which may mean asking for additional records, sending you for an evaluation, or having you come back to testify before with a medical expert or some additional expert in order to assist the court. Post-hearing review typically means the court is reviewing your file in order to put the facts and the circumstances together to write a written decision. There is no set timeline on how long it takes the court to review your file to finish writing their decision. Now, as I made a mention in another video, what typically happens is that there is a person that's called a decision writer that's tasked with the responsibility of writing a decision on your behalf for the judge. Now, usually one decision writer supports a couple of judges. So once it goes from post-hearing review to pending decision writer, it's basically sitting in this queue, or like I call it, queue is a nice way of saying kind of like a line, until the next available decision writer can write the decision. Then it goes from pending decision writing to decision writing. That means someone has been assigned the case. They're going to write the decision based on the notes and information provided by the judge. Once that occurs, and they've written the decision, they're going to give it back to the judge for review. The judge will sign off on it. They will go to a legal assistant who will put it together in its final format with all the nice little bells and whistles for purposes of all your procedural rights under the law, and then it'll go out to you. That whole process can take anywhere from a couple of months or longer. It shouldn't take longer than about 60 to 90 days, but depending on the judge, it can. The biggest thing that I tell people is that once your case goes into the decision writer's hand, once the judge has the case, and it goes from him, the decision writer, her, the decision writer, during that window, they're using that as an opportunity to evaluate whether or not they believe you're disabled or you're not disabled. If it takes a particular period of time, do not look at it one way or the other. If it takes a long time for a decision, that doesn't mean it's bad. If it comes out quick, doesn't mean it's good. Just know that once it has gone into the judge's hand and you come out of your hearing, it's all in his or her hands then. All you can do is wait.